the debate sponsored by OurFamilyWizard with me, James Evans, Safda Mahmood, and Elissa de Costa-Waldman. In this live session, you can put your questions to Elissa and Safda and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function and all questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within the next few days, so please do keep an eye out for this. So introductions. My name is James. As mentioned, I'm the head of UK professional education at OurFamilyWizard. I worked as a teacher for about 4 years before joining the family law world about 5 years ago, working with OurFamilyWizard to introduce family law practitioners across the country to our platform. I work with courts, chambers, firms, CAFCAS mediators, organisations, charities, and a variety of different organisations to help parents with their communication. We have been shortlisted for over 10 awards in our last 5 years in the family law world, and we're very proud to last year win the Working in Collaboration Awards and Resolutions Awards and the Innovation Award as well. So that's me. Safda Mahmood. Safda has extensive experience in both practicing and teaching family and children law for over 27 years. Safda practices predominantly in children law proceedings alongside his lecturing and legal writing. He has been a continuous member of the Law Society Children Law Accredited Scheme for approximately 20 years and is both an assessor and an author, having written in various legal publications, including the Law Society. He is a highly articulate and popular speaker who has a practical and pragmatic approach to his subject. As part of LAW2024 Online, Safda's sessions include personal protections injunctions, civil and criminal enforcement and options, and marital breakdown. What are the various options? We'll hear more about those today. Elissa de Costa-Waldman. Elissa is a practicing barrister at New Court Chambers in London. She specialises in financial remedy cases and is also an expert in cohabitation claims. She is a regular speaker on legal topics and an author, and during her career, Elissa has contributed to Blackstone Civil Practice, co-authored Family and Matrimonial Law, Cavendish, solely authorised Everything You Wanted to Know About Practicing Family Law, Cavendish in 2004, and last year contributed the chapter on trust law to Resolution's cohabitation book. Elissa encourages and practices non-court dispute resolution methods as an experienced mediator, collaborative lawyer, and family law arbitrator. As part of 2024 Online, Elissa's sessions include developments in dealing with conduct in financial remedy case and what's new in Schedule 1 Children Act 1989 cases. So to kick us off, we're going to start by going through some of the pre-submitted questions that you've asked. Just a reminder, if you have questions for Elissa and Safda during, please do pop them in the chat and we'll work our way through those. So the first question here, and Safda, I'm going to come to you first on this one, I think. When may someone pursue a nullity of marriage order as opposed to a divorce?
Okay, thank you very much indeed, James, and thank you for the introduction. Very, very good of you. So when you've got nullity of marriage orders, a nullity of civil partnership orders, they're not used very often, but when they are, they're very necessary. And typically it would be where, firstly, let's say the parties have not been married for long enough. The law as it currently stands, even with the new law that came in over 2 years ago, is you've got to be married for at least 12 months before you can commence divorce proceedings. Nullity doesn't rely on that. You can in fact go for nullity of marriage order almost straight away, as long as obviously the criteria are met. So that's one reason where people may pursue this. The other is where people may have religious and cultural objections to a divorce or dissolution of a civil partnership. As you can imagine, divorce, the stigma that it brings, the difficulties that it brings, not just financially, but obviously when it comes to children, but also, going forward in the community for people, can be significant. And that's where sometimes you may find that nullity is going to be potentially an option. So that's where it may well be sought.
That's really helpful, Safda. Thank you.
I've got a question. So just relating to nullity, and you're absolutely right. I've done several nullities and all based on religious grounds, because one was an Indian lady who was very young, arranged marriage. It didn't work out because it turned out her husband was gay, but she couldn't be divorced within that community, otherwise she'd never be able to remarry. So it had to be nullity. And it was, I felt very sorry for her because she had to give evidence as to why the marriage wasn't consummated. And it was really sad, like listening to her, you know, her naivety and the whole process. So I think one thing to sort of have a heads up about it is nullity is generally very sensitive, because I had another case where the nullity was based on non-consummation, but on both sides, until something happened. The wife was alleging that the husband couldn't get an erection, and he was alleging that she had penetration fear.
Right.
And then it all went pear-shaped because she got pregnant by someone. Just highlight that. Interesting case. Can't remember what happened, but the thing that I always remember about nullity, and because you don't do it very often, you don't remember, is there's an issue between what's a void marriage and what's a voidable marriage.
Yeah, absolutely.
So,
absolutely.
Yeah.
And what you'll find, you're absolutely right, Elissa, and what you'll find is when, you know, as practitioners, we do get a nullity case, you know, there's very few of them, you know, you don't get many, but when you do, it's significant. And like you say, you know, some of these cases where it's going to be involving very, very sensitive personal issues about non-consummation, about situations where there's lack of consent. I mean, I had one where we went for a nullity order where we were relying upon the person not being able to consent, and that's on the basis of them lacking capacity. So you're into the realms of, you know, a situation where somebody doesn't have capacity to actually enter into a marriage contract.
Well, that's what I was going to say. So if you're looking at a nullity on the basis of lack of capacity, how do they even manage to get married in the first place?
Well, this is where the case I had, it's where their parents arranged for them to get married through proxy. So it was actually done through the internet. And seeing it from the parents' point of view, and I know as practitioners, you know, we're not there to judge, are we? We're there to advise and, you know, run the case for them. But seeing it from their angle, they were saying, well, look, we're doing this because we feel it's our duty to enable our son in that case, who is an adult, to get married. You know, he's got just as much right as anybody else.
Indeed, and it is a human right to marry and found a family. It's in the Human Rights Act.
Exactly. But what the judge said is, well, actually, what you're providing for here is you're effectively providing for a carer. You know, you're arranging for him to get married to somebody who, firstly, has she given consent? You know, that was a big issue in itself, or has she almost been kind of pressurized into entering into this marriage herself? And secondly, what you're really looking for is you're looking for somebody to look after your child, your son, an adult son, who hasn't got capacity when you guys are no longer there. And that's not what marriage is. So it was a really interesting ethical dilemma that came into effect there as well.
Someone's asked in the chat, does nullity always involve a court hearing?
I think it does, doesn't it, Sam?
Yes, that's right. It would do, that's right. Although, I mean, a court under the FPR, they can excuse attendance if necessary. So it's a little bit like when we've got these kind of participation directions which came in, so they can excuse attendance. But more times than that, as Elissa says, you know, they're going to have to be there. They're going to have to be at court. And sometimes, as you say, if it's contested, it could be very, very personal things about, you know, consummation, like you say.
And are the rules, this out of my own interest, are the rules different if that nullity is then in a different country or a different proceed, you know, because if it's not Hague Convention and divorce is proceeded in a different country, the rules are different. Is it the same with a nullity? To an extent it is, in the sense that if we get a nullity of marriage order made here, then you're into the realms of will it be recognised in a country overseas. So it's the same with a divorce. In that regard, are we going to, is Spain, for example, going to recognise a nullity of marriage order that's conducted here? And for us to have jurisdiction, it's still based on habitual residence and domicile. So you're back to that again. So for us to even commence proceedings, we've got to establish one or the other. That's really helpful.
Interestingly, one of the changes last year was the minimum age for marriage and civil partnership has now gone up to 18, which I know for some people hasn't made much difference, but, you know, from 16 to 18, which does mean that even if, say, you've got, you know, a 17-year-old who has got married or purported to get married, and the parents are saying, well, look, we consented. Of course they can't, because there's a minimum age of 18 now.
Yeah.
Interesting.
So there is that.
It's a double-edged sword, isn't it? Because if kids wanted to marry at 16, you absolutely had to have parental consent.
Yeah.
So that the parents would be involved. Whereas if you remove that, which has happened, and anyone can go off and get married because they're an adult at 18, maybe that's not such a good thing.
Absolutely.
It'll be interesting to see where the casework is in that in a year's time.
Yeah, it will. It will. Yeah.
Right.
Really interesting. Thank you both. A couple of questions have come in off the back of that, actually. What constitutes willful refusal in relation to non-consummation?
Good question. I mean, I'm just thinking, Elissa, I know you had that. Did you want me to go through it, or did you?
Yeah.
Yeah. Okay. Sure. Yeah. So willful.
I just think what it demonstrates is everyone's interested in sex.
Everyone's interested.
Absolutely, that's right. Well, I mean, if the person who's sent in that question, there's some really interesting cases in the 1980s, in particular, if you have a look at them. I mean, for example, there was one case which did say that there has to be some element of penetration, but there doesn't need to be ejaculation, interestingly, and there has, of course, now we have to look at a situation where what if it was not vaginal intercourse, for example, so you've got difficulties there, and of course these are issues that a judge will have to be very sensitive about. But in terms of the willful refusal, it's willful where somebody is saying, look, I don't want to consummate, and the reasons they're giving are not ones which the court would accept. For example, if the person said, look, I don't want to consummate because, well, actually, I've got an inherited disease, and if I was to consummate without using protection, for example, then that means that you could then have a sexually transmitted disease and so forth. So
Safda isn't finding out. Forget the consummation bit for a minute. Isn't finding out that your spouse has some dreadful inherited genetic disease or something of that ilk, isn't that grounds for nullity? The fact that you didn't know and then you find out. Yeah. Yes,
there's a ground of, if the other person had venereal disease and you then entered into a marriage with them and you are unaware of that fact, there's Section 13(3), if I remember, of the Act, which says that if you're unaware of that fact, as long as you're unaware, you can still pursue a nullity on that basis. But had you been aware, then of course, then you can't plead it. That's right.
I'm glad we asked.
Yeah.
Acknowledge.
No,
that's helpful. Thank you. The other question here is, what is the rule about the attendance of certified journalists? It's a slightly different topic.
Transparency.
Transparency is obviously a hot topic, isn't it? So is there a rule? And if so, what is the rule about the attendance of certified journalists attending Children Act private law matters? This person had a case where a journalist had emailed the court. Where are we at?
Right. Here's what I think. It's not the question is not for us. It's not for us to get involved, because it's for the judge to make an order. You cannot, as far as I'm aware and as far as I know about transparency, if the and I'm assuming we mean journalists certified to attend, not certified bit loopy. You have to make sure you're entitled to ask to see their certification. They are permitted to attend, and if they are permitted to attend, they are permitted to attend private law proceedings, because there are for different types of proceedings, whether it's family or it's civil or it's whatever, a court of protection, there are different template transparency orders, and it is very clear from the template transparency orders what is and isn't allowed. So even, and I know for many seasoned practitioners, and I'm very seasoned, as you can tell by the hair colour, for many seasoned practitioners, this whole thing of allowing the press into what are otherwise private and confidential court proceedings, it doesn't feel right. It goes against the grain, as to so many things that go on in the courts these days. We have to accept it. We have to deal with it. And It's for the court to make the transparency order and for the journalist to stick to it. And there's lots of stuff in red on the face of the orders about what will happen if they breach. So we as practitioners, we need to be polite, because it will come back and bite us in the bottom if we're not, when someone, you know, has shown us their certification and they are permitted. We have to go with that. Very often, something else that you may not know, but this has been the law for a long time, and any of the allowed press, certainly it's happened to me before any of the transparency stuff. There's a really lovely court reporter at the RCJ called Neville, and Neville always follows me in my Talata cases because they're funny, and he asked for my position statement, and the first time it was like, oh no, you can't, it's mine, you can't have it. No, but actually they can, and there's case law on it that they can. So that was even before the transparency. So they are entitled, if they ask you or your counsel for a position statement, you must give it. You're obliged to give it.
Interesting.
The transparency order itself will do whatever is necessary to maintain confidentiality and anonymise where necessary. So I hope that answers the person who asked that question.
I think so, and you can find out more information on the Transparency Project. It's Lucy.
Absolutely, yes.
Comparison where that will be outlined. So this person, in response to that, Elissa, has asked, so if I suppose they assume here that if the court has approved that a journalist can be in the court, does the client have any base to object that in any capacity?
Not really.
Okay.
And on the upside, I have seen clients, not mine thankfully, who've gone up to the journalist and said, do you want my story?
Absolutely, yeah.
And they do, yeah.
That's right.
So, you know, you can have a really irate, perhaps alienated father who just wants to, you know, have the catharsis of spewing his guts to a journalist. There's not much you can do about that, but the journalist still has the obligation to keep it all anonymized and confidential.
That's right. So there's still that kind of restriction there, isn't there? There's still those restrictions. You can't, you know, divulge an info which will identify the child, the school, you know, where they live, all of that, you know, is still there.
And it really, when the judge is making the order, it is for the practitioners in the case, if they want it sort of tight, you know, there's a template, but equally it doesn't stop you tightening things up where you think it's necessary and appropriate.
Absolutely. I think one of the interesting points about, you know, the Transparency Project, and it started life, as Elissa says, you know, it's in private children. It started in public law last January, and from January this year, they've moved on to financial remedies courts as well now with some of them. But what would be interesting is once, you know, a lot of these, the reportings are done, how representative are they of the actual, you know, case that took place? Because, you know, if, for example, one of my cases was reported, I'm going to read it and think, if I look at it objectively.
For sure, yeah. But I think we have to, there's a couple of points that arise from that, which I think are quite important. If you want the accurate reporting and outcome, you look at the law reports, you look at the judgment, because we hope, unless it's really appealable because it's totally wrong, that that is accurate. I think we have to accept that if a journalist is going to report, there's going to be a slant. There will be a certain slant because, you know, good news doesn't make good news.
Yeah.
The other thing that I will say, which I am waiting to find out, and most of you will be aware that I don't do public law, but many people in my chambers do. And they are finding, because in public law you have numerous parties, don't you? You know, the parents, the child, the guardian, this one, that one, the local authority, any number of parties. And if you've got several children, they're all possibly differently represented. I don't know.
That's right.
Yeah. So you've got numerous parties, and what's going on, as I understand it from my colleagues, this is purely anecdotal, I've not experienced it myself yet, is that there are issues that are arising over the seeking of a transparency order and what exactly the order should contain, such that there is satellite litigation purely and simply on the transparency order, which of course I'm concerned about, because my understanding is, the little I know about public children law, is you should get your cases done in 26 weeks. Wasn't that the general idea? I know lots of them aren't, but you know, here, you know, we've got the Children Act that's got the principle of no delay. We've got the Public Law Protocol, which is 26 weeks to get done and dusted. And then thrown into the mix now, we've got transparency, which has the capacity to cause delay, lengthen proceedings, which is not necessarily, as far as I can tell right now, in the best interest of the children who are the subject of those proceedings. So, you know, I think we've yet to see how that pans out.
Absolutely right. And I mean, on the public law side, that is happening. You're absolutely right on that. That is happening. And I suppose one case I was involved in, the judge was emphasising that actually with this pilot, there is a need for the representatives, the lawyers, plus the press or the legal bloggers, to have these discussions even before the hearing. So hence you're spending less time, court time, the 26 weeks to thrash this out. But as you can imagine, inevitably there's still going to be issues which are live issues, and the court needs to make you know, decisions on them. So yeah.
And who's paying for these proceedings? Because most of them are coming out of the public purse.
They are. That's right.
It's us.
Yeah, that's right.
Really interesting. Thank you both. Sticking on private children proceedings, someone's asked what your views are on QLRs, qualified legal representatives.
Yes.
Yeah.
Start with this one. So they don't. My understanding of this, because you may recall that I did this as a presentation, I think last year.
There is a good article on it on the on the Transparency Project website as well.
Yeah.
Yeah.
And I don't think, for precisely the same reason, lots of people have either stopped doing legal aid or don't do it at all. People aren't being paid enough to do this. There aren't that many people qualifying as qualified legal representatives.
Right.
It's actually not working.
Yeah.
It's not working. It's not my, and again, this is purely anecdotal because I cannot speak for what goes on in all the courts up and down the country. It's only what I experience. And in my experience, it's not working in the way in which it was envisaged, because there aren't enough people in a pool to say, right, we need X, let's go and get one. It's just not happening.
Absolutely. And in fact, earlier this year, I think it was in January, the QLR guidance was reissued. I think they've got to issue number 2. And one of the things in there now is QLRs who are having to travel, they are now being remunerated for their travel, and indeed even overnight expenses, you know, subject to obviously eligibility and, you know, caps and so forth.
I'm doing that on legal aid.
Tell me about it. That's right. Because what you're finding, and I know as a fact, I know a number of lawyers who do a lot of this, but there's such a few of them. There's just select lawyers all around, you know, England and Wales. There's not many of them. So I know one lawyer, for example, who lives, you know, easily about 200 miles away from that particular court. And they will get the phone call and say, right, you know, are you available on whatever date? And they're saying, look, I'll do it, but it's got to be remote. You know, I'm not spending, you know, 3 hours one.
No, but it's not just paying for your travel. It's the time element.
Time element, the cost, yeah.
And even, you can use your laptop on the train. Not in my experience, because the Wi-Fi is in and out. It's so unsatisfactory, isn't it?
Absolutely. And the president has had to, I mean, there was a judgment earlier this year where he's had to give in, and he's had to say, look, the reality is, even with these expenses that we're now paying you with the hotel costs, if you're still not getting QLRs, which the reality is, as Elissa says, you're not, he's saying you've got to go back to the drawing board, which is the judges having to ask those questions again.
Which is not right. That's not right, because you're putting the person in the judgment seat in the person, you know, in the inquisitor's seat.
Absolutely, because that's it, and because that's the whole purpose of this, wasn't it? It's to stop the judge being in that almost a bit of a conflict situation of really they need to be impartial, and then suddenly robustly cross-examining, you know, the alleged victim.
Isn't, if we go back even further, isn't the reason this whole thing started is because of the removal of legal aid, that people haven't got, nor can they afford, legal representation.
Yeah. Exactly.
It goes right back to that, which is
does.
wrong, isn't it? Just totally wrong.
And I mean, in the criminal courts, and again, this is anecdotal because I don't do the criminal work, but there's, I think it's section 36 and 38 of the criminal procedure rules, which, for what I've been told, is you've got advocates who do the same job in the criminal line of field, but the payments are done privately. So, and it's all paid for by the MOJ. So it does make you wonder. On the family law side, it's the MOJ who are paying, but it's, you know, it's kind of legal aid and very basic legal aid rates. And yet in criminal it's it. So I don't know. I just think it's going to have to be looked at.
Well, that's someone has asked on that, essentially, you know, if the QLRs are likely to be subject to complaints by parties in the cases, who covers that with the insurance?
That's a good question. That is a very good question.
That's a very good question. In fact, because one of the issues I've sometimes raised is this: what if I went and, you know, I mean, you're not even technically representing that person. You're there providing an unbundling
you're just
service.
asking questions.
That's right. So let's say I went and met Dad, for example, on a fact finding on a private law, and he wants me to cross-examine his ex-partner, the mother. Let's say he's prepared 200 questions, as people do. You know, he wants me to put all of those. Now, the QLR guidance does say I'm allowed to decide what I ask, so he can't dictate. So I decide.
But you're not allowed to advise.
Absolutely. I'm not allowed to advise. That's right. So let's say of those 200, I ask 10 questions, and let's say findings are made against him. Am I going to be subject to a complaint? And then you're into the realms of all of those. And as you say, that's an area that's, you know, needs exploring. You know, is this going to be covered by the insurance?
Well, I think anyone who's going to do it needs to check with their insurers, certainly. And secondly, I think it is incumbent upon anyone who is in the position of a QLR to make it abundantly clear, maybe get the client to sign something to say, this is what I'm allowed to do, this is what I'm not allowed to do. And to sign that they understand that, so that you've got something in writing that shows you have explained, they've understood it. Because, yeah, I mean, you know, we've yet to see an insurance claim, a negligence claim on one of those. And I think that's a really good question. Thank you, whoever raised it.
Well, and someone else has commented saying that they've done some QLR cases in their firm, but have now stopped because bundles were arriving from litigants in person the night before, or even the morning before.
Welcome to my world.
They said it's not worth the stress for the money and the risk of complaints.
Yeah,
absolutely. Getting a bundle the night before, that's a dream.
Oh, hey, that's normal in my life, you know.
Absolutely, that's not bad.
If only there was an app that would help you with your bundling. OurFamilyWizard. Right.
If only.
If only. That's it for the live questions. Thank you for those who please do keep asking those questions. Keep them coming in. And as I said, that someone a bundle is a loose term. They've said in response to that, a bundle is delusional, which is
very.
We all agree with that. Please do keep your questions coming in. I'm going to go back to the pre-submitted ones now to catch us back up. So going back to that list, Elissa, is it possible to claim a fighting fund from the other parent in a Children Act proceedings?
Yes, it is. Absolutely. Yes, you can. It's similar to what you can do under the Matrimonial Causes Act with your legal services order. It doesn't really have a name other than I want a bit for me. 'Cause there was a famous case, I think it was Ray S., where the dad had abducted the child to a non-Hague Convention country, and mum needed to fight to get the child back. Dad was incredibly wealthy, and she got her fighting fund on the basis it was in the best interest of the child to be brought back, and for mother to be able to have a fighting fund to do that. So yes, most definitely.
Absolutely.
That's very helpful, concise. Thank you.
Easy one. Sorry, I just promised this is going to sound really unprofessional. I'm going to wave. Colette Burke, hello. I promised I'd wave at you.
You're a celebrity now. Well done.
Absolutely.
Get me out of here.
This is a question I think that I'd be interested to hear from both of you on. How should judges deal with parents who choose not to engage in the proceedings at all?
Okay.
Well, that's my Zoe case. That's my Zoe case.
What's your Zoe case?
Yeah. And I think that was Cobb J, who, and it was an interesting case because what was it? Interesting on a number of levels, because the dad had never even met the child.
Wow.
Yeah. And he'd engaged with the proceedings right up until the final hearing, when he'd had enough, as so many of them do. This was a Schedule 1 case, but I think you do get dads that disengage at the last minute with the parental alienation cases, because, you know, when you've been at it for 3 years, 4 years, 5 years, and the court's with you, but the mother isn't, you just think, I'm going to give up.
Yeah.
And I mean, I remember there was one judgment, I think it was either, I'm not sure which president it was, whether it was Sir James Mumby, it's probably him when he was president. And there was a judgment, I've forgotten the name of the case now, but he said, you know, a father has walked out of my court in tears.
Yeah, that Reedy case, it was Mumby.
Remember that one?
That's right.
And yeah, and he actually said, I don't blame him. I don't blame him if he gives up giving up.
I mean, that one, there were something like 16 judges who heard that case.
Yes, yes, you're right. Yes, yeah. And
5 years. 5 years, and you know, after 5 years, you just give up, don't you?
Well,
what can I do?
And I've had a client myself where I've actually said, we've had similar for several years, and he said, I don't know what to do, because it's not just the financial resources, it's your emotional resources. So back to the question, how should a judge behave if someone chooses to disengage? Well, I think Cobjay got it absolutely right. He gave, although I'm thinking, why should it be extra special just because the dad's not there? He made it clear that he was going to give almost an extra reasoned judgment, so that whatever decision he was going to make at the end, every step of the way, it was going to be completely transparent and understandable by the father, who was not going to be at the hearing, and whom he commended for how well he had conducted himself and his case up until this point, and that he'd been absolutely compliant with all court orders and everything. But I think he understood the difficulty. What was quite interesting to me in that case was the father was very much very critical of mother, almost alleging alienation, but not actually using the word, but almost alleging that, when the father's case was, and he lived in America and mum was here, that he hadn't come over because of work commitments. There was a 20-year gap between the parties, but so what, you know. He hadn't come over because of work commitments. He was sickeningly wealthy. So it wasn't the money, you know, it wasn't, I can't afford the flights, it wasn't that at all. And he was trying to say to the judge that he felt the mother had kept the child away from him. And this was a child that had very, very special needs, very special needs. So the judge did observe, in as non-critical a sense as he could, that the father hadn't sent her a Christmas card or a birthday present and all of that. So, you know, if you really want to engage with children, presence is, you know, as a grandma of 7, presence is definitely the way to do it.
Absolutely.
But I just think, from Cobjay's point of view, shouldn't every judgment be super, super reasoned so that anyone can pick it up and understand the point of it? Why does it have to be just because you don't turn up? And the other thing, I think he had to be super careful, because on that particular occasion, recognising, you know, mum pitched up with solicitors, counsel, a whole retinue of people. And on that basis, I think the judge would have been careful about equality of arms, going back to what, you know, human rights and all of that.
Yeah, absolutely. And I mean, I've had it just kind of, I suppose, seeing it from a slightly different angle. I've seen a fair bit of it in public law cases where, and I'm not saying for a moment, you know, this is because in public law funding is different, you know, it's non-means and non-merits. But sometimes, you know, you will find that a parent won't turn up repeatedly, you know, and that's where, you know, sometimes you find judges are going to be extra careful there. They're going to make sure it's very clear judgments, you know, copious opportunity for the parent to turn up, for them to engage. Because of course, as you say, it's back to Article 6 again, isn't it? But the parent can very easily say, well, hang on a minute, you didn't give me the right to attend. And there was an adoption hearing a few years ago on this point. It was in the midst of the first lockdown we had, where the judge decided at the final adoption hearing to make the order, but to dispense with the need for anybody's attendance.
Which would be quite sensible,
yeah,
in the context of a pandemic.
Absolutely, absolutely. But in fact, the mother appealed, and because the adoption rules, as they stand even now, are there's got to be a hearing, and the parent is entitled to attend. But ultimately, the Court of Appeal was saying, well, look, mother, even if you did attend, you couldn't make any difference to the outcome. So yes, there was a failure, but you didn't have a right to make legal argument there. So to be fair to the courts, I think the judge will try his or her level best to accommodate, but there's got to be situations where they've got to be able to get on with the job as well and make decisions.
Yeah.
Thank you both. Elissa, you made reference to but didn't say alienation.
Yeah.
Where are we with parental alienation? Is it a term that's been officially recognised, or are the courts disregarding it? Where are we at?
Clients use it all the time. Solicitors use it a lot. I use it. You can say parental alienation, those two words, we all know what we mean.
We know what we mean.
Right? We all know what we mean. It's usually, sadly, the mother who says, they're my babies, you're never going to see them because of X, Y, whatever, right? So we know what it is, but it's like many things within children law. It goes through fashions. And I remember, and I'm sorry if I'm telling too many war stories, but I remember when I first started, you'd wait for the allegations of sexual abuse again, towards the child, because that meant months of social services and child protection investigation while mum's building up status quo. That kind of went out of fashion. And then, you've got parental alienation. It is a term, it depends in which quarters, whether it's popular or it's not popular, or what phase we're in. Historically, it sort of goes in and out of fashion, but we all know what we mean by it.
We know what we mean, that's right. And I mean, what you're finding is, because there were a couple of judgments on it last year, which are, saying, look, it's definitely not a label. So it's not the same as saying, right, you have got a disorder known as parental alienation. It's not a label. It's not
disorder, is it? It's a form of behaviour. It's like coercive control.
Exactly. That's what it is. So therefore, some judges have begun to start using the term alienating behaviours. So they're deliberately not saying parental alienation because they don't want to fall into that trap of...
Tell me who else is doing it.
That's it. So it's kind of alienating behaviours. But what is interesting is we got it wrong for many years, because we were asking court-directed experts, and social workers and guardians and psychologists and psychiatrists to give us an opinion on whether mom or dad were exhibiting alienating behaviours. But actually, we shouldn't be. It's the judge who determines based on the information we put to him.
Because it's not, as you rightly say, it's not a condition. It's not a personality disorder. It may well be that the person who engages in it has some other personality disorder that predisposes them to engage in that kind of behaviour, but it's not straightforward cause and effect.
That's right.
No, they're often linked in with something like narcissistic personality disorder.
Absolutely, yes.
Conflict personality disorder, of which there are books and podcasts and
I've got several on my shelf.
There you go.
That's right.
But Safda, you talked about experts, but is there not a push away from experts in that capacity, though, from the court?
There is, but only insofar as determining whether there is alienating behaviours or not. But then let's say the judge has found that, I don't know, on 4 occasions, taking mother as an example, she has alienated her children. Let's say she coached them, she primed them, and there's evidence, and the judge has made findings on that. We're then back into the realms of, okay, now that judge have made these findings, okay, what are you going to do about it? Because the application before the court is for, say, contact. So based on these findings you've made, will you now be assisted by maybe a risk assessment, a social work, Kafka-based, psychological, psychiatric? So there's still a need for experts, but it's afterwards,
further down the line.
Further down the line, exactly. And interestingly, talking about, you know, how perceptions change. I remember years ago, and you guys will remember this, we used to use the term Munchausen syndrome by proxy.
Oh, yes.
You know, and that kind of term has gone. Now we use the terms FII, fabrication induced illness or induced illness by carers. Because the idea is it's not a personality disorder, it's not a mental disorder, it's not a label, it's behavior. Somebody is subjecting their child to that form of, you know, behavior in that way.
In a sense, Safda, we're swapping one label for another one.
We are, if you think about it, yeah.
And I think I may be shot down in flames any moment with what I'm about to say. In the same vein, that there are those that say, you can't say that a woman is pregnant. You can't call pregnant, you can't call women mothers. It's parents or people, and you have to say pregnant people. Is that why we can't say parental alienation?
Yeah.
Even though it's usually a parent who's doing it. So I fear, and I may get shot down in flames there, I fear that the law, as in so many other things, is being pervaded by a bit of wokery. My opinion does not reflect the organisation. It's just my opinion. If you don't like it, I apologise.
As you said, Elissa, I think a lot of these things are trends.
Yeah.
You know, it will be talking about a different topic in 5 years' time that might hit on the same issue. Sure, we will be. But thank you, because those were my questions. So I was just being greedy now and asking things I did. I hope that's okay. Let's go back to some of your questions here. Safda, we've been asked the question here about the effect of a certain marriage conduct, and I'm going to pronounce this wrong, so I apologise in advance. Is it the Nika?
Oh, Nika, yeah, the Nika. You're almost there. Yeah, the Nika.
Marriage conduct in England and Wales. What was the effect of that?
Yeah, sure. So Nika is really just a name for the Islamic wedding ceremony. That's what it is.
Sure, and I apologise again for
no problem at all. No, I think you pronounced it very well. Thank you. So the Nikah is the wedding, so the Islamic wedding ceremony, and I mean, there was a big judgment a few years ago, the Akhtar and Khan judgment in 2020 by the Court of Appeal, and what it basically has said is this: if, let's say, as in that case, you got husband and wife, and I use that term loosely because in fact ultimately they were not husband and wife. If they had
they never had a record marriage in this country.
Absolutely. So 18 years previously, they had a nikah, they had the Islamic ceremony. And, you know, it's just the same, you know, as what it would be in any other wedding in that regard. You know, you go there, you've got the imam who's the religious preacher, you've got your witnesses, you sign. It's just like any other in that way. 18 years later, 4 kids, you know, happily married, you know, using that term loosely for many, many years, lots of holidays and everything else. The lady then decides to end the marriage, only to be told, sorry, but you know what, we're not even married. She said, what do you mean? What have I been doing for the last 18 years then? And the court said, well, actually, because it's a nikah you've had, you haven't complied with the formalities here, the Marriage Act of 49 as amended, you need to have a civil ceremony. A marriage is a process. You guys only did the first bit, you had your nikah, but you needed to have your civil. And because of that, because you knew you had to do this and you didn't go through with it, and we know that wife, you know, you were putting pressure on him to sort it out, but he never did.
Yeah.
Well, the fact is, sadly, you haven't complied with that process. So the most you were cohabiting. It's not even a void marriage. It's not even a voidable marriage. It's you know, effectively it's a non-marriage, because the most you guys were doing is were cohabiting. And as Elissa will, of course, will be able to emphasize, is when it comes to the finances, this is the big problem, because of course there is no relief at all under the MCA. You're having to rely on talata at best.
And as cohabitants, one of the biggest differences, no spousal maintenance, because there's no spouses, no obligation to support each other. It's simply about the property. No obligations in relation to pensions, nothing. So, you know, really serious consequences. And I think the message is for anybody, and in fact, it's not just the religious ceremonies, it's people who choose to go and marry abroad.
Mick Jagger, right? That's what happened with Mick Jagger.
Yeah. The marriage on the beach.
Yeah.
Does that, you need to check, does that marriage comply with the legal formalities of where you're doing it?
That's right.
Because if it doesn't, it's not going to be valid here, and you're back to square one.
Exactly.
Remarkable how often it comes up that here we are talking about it as a common mistake.
It is. People,
yeah.
In the same way that people come to me as cohabitants and think the outcome is going to be like a divorce, financial remedies case, then I have to sort of explain it's not. When people get married, they don't necessarily think about the formalities and the fallout if you get it wrong when you're getting married.
Absolutely. So it's
really
huge issue.
Yeah.
Right.
We've got about 10 minutes left. So if anyone has any more burning questions for Elissa, please do ask them. They love answering even the hardest questions. So I dare you to challenge them. With our remaining time, we'll go back to the pre-submitted questions. We were just talking about finances, Elissa. So what are the general legal principles the court will consider in making financial order in respect of the child?
Well, we start with, I think the leading case on that was one of Thorpe LJ's judgments in Ray P and the Fabulously Wealthy Father. And I think it's a pity that all of these cases are coloured by the fabulously wealthy, because they're the ones that can afford to go to the highest courts in the land to hear these things. But generally, your starting point is the judge will look at obviously all the stuff that he needs to look at, or she needs to look at, in section 4, paragraph 4 of Schedule 1 to the Children Act, which is a kind of section 25 list, but slightly different. And one of the things that you won't find in there is standard of living. But all of those things. And then the court will look at, what the parents have got. Does the child have any resources financially, like a trust fund or anything like that? And the court will start off with, what do you need for a housing fund? Because the level of the housing fund will generally determine everything else that you need. The size of the car, what you need to furnish the house. And then the other thing is, what, if anything, does the carer require? And this is really important. And I've got a couple of things to say about this. Slide 22 in my presentation, and the case of Collado Fuchs, talks about all these wonderful things, and something called a HEXA, which is an acronym that Mostyn, bless him, he always does his acronyms, invented. It's essentially the fund for the carer to take care of the child, but it's not for the carer personally. And what the case talks about is, the carer needs, maybe you need a nanny because you're working, maybe you need a cleaner because you've got a child with special needs and you can't clean the house, and stuff like that is going to benefit the child. But membership of Annabelle's nightclub, that's just for the carer, for the carer's personal benefit. So it's not on to provide the carer with enough that there is a surplus to have a savings fund or to put into a pension. That's not permissible. But an element of the carer as carer for the child and benefiting the child is allowed. And the other thing that I wanted to mention, so pens at the ready, folks, we often, and the guidance is that we look at what the fund should be. We use the child maintenance service calculations as a guide. Now, obviously, that gets difficult, or more difficult, the higher the earner of the paying parent. There's a really good case, James and Seymour, and the reference for that is 2023 EWHC 844 FAM page 675. And that is the now new wisdom with tables of how to calculate what essentially is high net worth, very high earners that are way off the scale of the CMS, how to calculate what the payment should be for child maintenance.
Listen, can I throw this at you? It's a kind of offshoot to the Schedule 1 side, and it's this case earlier this year I was just really interested in. It's the one by Mr. Justice Peel where you had the father who's a member of the royal family overseas. He raises the millionaire's defence.
Oh yes.
So the mother of this child, two children.
I can pay whatever it is.
Yeah. So he says, you know, and
then he kind of rolls back on it, doesn't he?
He does.
Then he rolls back.
He rolls back.
And he realises how much he should have to pay.
Absolutely. There was one thing in that judgment that made me smile, actually, because it said he's a member of the royal family overseas, but he doesn't fulfill any royal functions. And I thought, look at that. He's got the name, but, you know, doesn't seem to.
Sure, his name's not Harry.
I thought you might say that.
And so he raised the millionaire's defence, but I was just interested when the judge said, yes, you know, there's been case law on that, of course, but we still need you to give us some information, because if you're saying, look, I'll pay whatever, you know, she asks or he
But
asks.
that's the very nature of the millionaire's defence, which was used. I don't want to have to disclose everything. Yeah. Just give me a number and I'll pay it.
That's it.
Right?
That's it. But of course, if they say, okay, look, give us, I don't know, 10 million or something. But if
how do you know? That might not be enough.
Well, that's it. Exactly. How do you know?
Because, and you're right, because the child is entitled to be brought up in a way that is not out of kilter with the parent who's paying the money.
That's right.
And that's what the case law says.
That's what it's
about. Yeah. I mean, that is an interesting question. I don't think it has ever been resolved. And certainly in matrimonials, I have not, even with all these, you know, the Russian cases where the money is way off the scale. No, I've not seen the millionaire's defence raised in recent times. And although that father did raise it in that case, nonetheless, I still think it was looked at in the normal way.
Yeah, that's right. That's right. And I think, really, I think he pleaded. He said he had about 111 million or something, which is a lot, but not what I thought it would have been. I thought it'd be into the billions or something. But there you are.
Yeah. Not a difficult position to come from, is it? I think this will probably be our last question, unless someone wants to jump in with a final live question. But we've asked one more live question, Safda and Elissa, for both of you, and they've asked both of you, what do you consider on the new pensions advisory group report from January of this year, and do you think it'll make much difference in the way that financial cases are decided?
Well, the new pension report. What exactly? Because they're massive, you know. The initial PAG report was 176 pages. So I'm not quite sure the breadth of the question. What I will say is, and there was a case recently, another Hess case on pensions, which I can't remember the name of it. It's in my head somewhere, but check it out. There's a new pensions case, I think, based on some of the new PAG guidance. All I would say is that for me, in practice, I find the PAG guidance invaluable. I love the template letters. I think that's really helpful. I like the idea that if you've got pensions that are below an aggregate of 200,000, you don't need to worry about reports. You know, there's certain sort of watersheds and boundaries that you think, right, if it's this, it's that, and if it's that, it's that. And I think whatever the latest guidance says, PAG is invaluable to us as practitioners.
Absolutely right. I concur with that. It is, you know, a very useful document, and you know, with pensions, as you can imagine, you know, often it may actually be the main resource, you know, over and above even the house or houses, and with that in mind, we've got to get it right. So it's excellent. It's excellent. It's a very good document. It does, from what I looked at it, it does put a lot of the kind of current thinking, obviously the changes which we've had to pensions over the last few years, the kind of McLeod judgment, those kinds of things. So yeah, so I think it's excellent, and it's invaluable. A
nice, easy to read, digestible 117.
You know,
I wouldn't go that far. Easy to read. I would suggest that if one is suffering from insomnia, you might want to take it to bed with you.
Well, that's one piece of advice to leave people with.
No, I mean, I just say that, you know, as a joke, but it really is a good document. I do quite a lot of direct access, and if we have to instruct an expert, I go straight to that for the template LOI letters, all of that. Yeah. Brilliant.
Well, as is often the way with these sessions, we've dropped in the ocean of some of the pre-submitted questions and gone off in different directions. But that is all we've got time for today, unfortunately. But thank you again to Safda and Elissa for the Family Law Shape the Debate, hosted by us, Our Family Wizard. Don't forget to sign up for the Solicitors Group newsletter to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's session will be sent out by email within the next few days, so keep an eye out for that. And there's still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And there is still time to find the complete event, including a recording of this session, if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The online exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue worth £35 plus VAT. You can also visit our exhibitor profile for more information on Our Family Wizard. And if you do want any more information, please do have a look on that profile. We do free training for anyone, updates on what we're doing and where we fit in the family law world these days. And finally, feedback forms will for the event will be sent out when the event closes. And by completing this, you will receive that CPD certificate. Safda, Elissa, pleasure to see you as always. These sessions are great fun. I'm not sure when we're seeing each other next, but hopefully sooner rather than later. Thank you for your time and see you all soon.
Lovely. Thank you very much indeed.